Hi there, everybody. Welcome to the AFSA Extra Credit Podcast. We have a great show for you today, but this is the last time you will hear my voice until the end of the program, and that's a really good thing because our subject today is the valid when made rule, a decade after Madden. This is a pretty complex legal topic, so I thought it was pretty smart to have experts take care of it. We are joined by Steve Obermeier and Jeremy Broggi, both partners at Wiley, Rein, LLP, and Frank Borchert, who's the former CLO, CAO, and CRO at Best Egg. They talk about a number of different aspects about what is the valid when made rule, the Madden versus Midland Funding case, and a whole bunch of other items, including the federal regulatory response and the judicial response. They walk through the topic really well. Without further ado, I'll turn you over now to Steve Obermeier with Wiley Rein, who's going to lead this conversation with Jeremy and Frank.
Well, Dan, thank you for that introduction. Again, my name is Steve Obermeier. I'm here with Jeremy Broggi and Frank Borchert to discuss on this 10th anniversary of the Madden decision, the valid when made doctrine, and really where we stand both legally and practically in the industry at this point, a decade after that very consequential decision. And with that, we'll just get right to it. I think probably most of our audience is familiar with the valid when made rule, but Jeremy, maybe you could just give an explanation of what it is and then sort of just summarize a little bit how it came to be.
Sure. Thanks for that, Steve. Valid when made, it's really the idea that a loan that's valid at its origination remains valid after it's transferred, even if the loan, as part of that transfer, moves to a new jurisdiction, say New York to Pennsylvania or something like that. And that's obviously important for stability. And so this rule is, it's well established by the early 19th century. We cite in the paper a couple of Supreme Court decisions from the 1820s and 1830s, but if you read those decisions, they make clear that the rule is much older than that, has its roots in the English common law.
And Frank, maybe you could just give the audience a little bit of an explanation. Why is this rule so important, and why does it go back as long as it does?
Sure. Well, I don't know if I'm old enough to give you the full history of how this rule worked itself out, but certainly for the modern financial industry, this rule is really critical in helping to ensure deep liquidity. We have really a national lending market, and so the fact that and we have, if you look at the underlying elements of that, banks play a role, but a lot of capital is provided and creates liquidity within our system from non-banks. And so when you put all that together, bank loans that are then sold to non-banks really help both banks and non-banks and ensure that you have plenty of liquidity in the system. And net result is customers and businesses benefit from having that deep liquid market. The United States markets are the deepest and the most liquid in the world, and valid when made rule allows that to occur.
And Frank, I assume certainly in making these transactions and these deals, as always, certainty is an important part of that. So maybe you could just explain, again, this is kind of leading up to Madden, the importance of certainty then and how it allowed the market to function the way it did before Madden.
Right. Investors, who are buying loans, and again, a loan can be made, for example, even in the fintech industry, you'll see loans being made and then being sold several times, including ultimately into a securitization transaction. And if market participants can't be comfortable that loan sale and the terms of the loan are entirely valid, then many investors won't purchase at all. They'll just avoid those loans, and other investors will want a discounted price. And so that both reduces liquidity and ultimately increases the price of the loans to the ultimate borrower. So really that certainty and the feeling of trust that's engendered by that adds both liquidity and thereby reduces cost to market participants.
So that's really helpful, Frank. And I guess that brings us to 2015 and the Madden decision in the Second Circuit. And I'll walk through that a little bit for our audience. Going into that decision, as Frank said, we had this certainty allowed the market to operate efficiently and again with certainty. And then Madden, the Second Circuit, ends up allowing a putative class action lawsuit to proceed against a third-party debt purchaser based on allegations that the loans that were validly made in Delaware were usurious under New York law. And in reaching that decision, the Second Circuit, this is the first time a decision like that had been reached, the Second Circuit held that the National Bank Act did not preempt the New York usury law because the purchaser to collect the debt on the loan was not a national bank or a subsidiary or agent of a national bank. And so then on remand from the Second Circuit, the district court certified a class action comprised of people subject to the collection attempts for the Delaware loans above the interest rate allowed by New York law. And the district court reasoned that to apply Delaware law would violate a fundamental public policy of New York. Again, this was sort of, I think out of left field for a lot of people. And it created turmoil in the lending markets. It was, although the decision was inconsistent with the long settled rule, valid when made rule, one of the problems with the case was that the parties actually didn't present the valid when made rule in the case. So one of the issues with Madden was it was not really sort of well argued and well briefed, and it's one of those situations where that led to after the ruling, a bunch of financial institutions appeared as friends of the court to urge both a full Second Circuit review, overrule it. That, of course, didn't happen. That's called an en banc decision. That didn't happen. On seeking certiorari at the Supreme Court, the Solicitor General weighed in too and said, Madden's not correct. It fails to recognize that Section 85 of the National Bank Act actually incorporates the valid when made rule into federal law and should have preempted it. But ultimately, again, the Second Circuit didn't review it fully. The Supreme Court decided not to take cert. And so, unfortunately, Madden remained intact. That left this all of the certainty that Frank said was important now was thrown into uncertainty, particularly in the Second Circuit. The industry was left to sort of react, and there were consequences not just within the Second Circuit. This, people, the plaintiffs bar interested in this certainly took this as a signal to bring these types of cases out elsewhere, and for a while it was a difficult situation. Frank, when the decision came out, maybe you can give the industry's perspective of sort of how it affected the day-to-day workings and what I know you lived through these battles. So if you could give a little bit of your background on that.
Sure. Yeah. I know when the decision came out, I think at first there was quite a bit of surprise, but then as investors started to incorporate the decision into their thinking, that really had a notable effect. And this is actually, the effect has been studied. There were some immediate studies done out of Columbia University by professors who noted that there was a large drop-off in lending, particularly in New York, and particularly from fintech companies who at that point were a substantial source of consumer credit to New York, near prime consumers or even subprime consumers. So you had both a drop off of credit availability and an increase in price. and a lot of investors walked away from the space. And so those first couple of years, that was an immediate impact. All of a sudden, basically companies that own loans were not able to get certain types of loans into securitization transactions. Some other market participants were actually sued, as you noted, Steve, in class action lawsuits. And then you started to see ripple effects as companies, including the one I represented, were sued or investigated by certain states, saying, "Hey, maybe this same rule applies in the case of our state, not just the Second Circuit, and let's test it out as a legal theory." And again, so the net for the industry and for consumers and businesses is that the cost of credit started to go up, availability started to go down, and this is well documented.
Yeah, and Frank, in my recollection, and you may remember a little bit better, but one of the complicating factors, particularly with those when the state started coming after this, was trying to deal with them in state courts, and it was a really challenging situation to notwithstanding the fact that industry had the better position here, as even the Solicitor General said, it was very hard to get that. If I'm remembering correctly, in front of the right decision makers to get you the right decisions. I don't know if you can comment on that a little bit more.
Yeah, I mean, certainly our experience and the experience I saw with others was that you start to end up in a litigation game. Apologies for calling it a game, but you're in a litigation scenario where state judges are giving deference to state attorneys general, and they and even though you may have the better federal argument, you may not get any deference to that. So that's a real challenge, and one that we faced. And maybe just to put a cap around that, Steve, I would say I was told by one relatively senior government official, well, it's almost certain that you will win once you get to the Supreme Court. And the last thing any company wants to hear is that they have to fight something all the way up to the Supreme Court.
That's not cheap.
Yes.
To get vindicated.
Full
Yes.
comfort.
Yes. And again, for business people, how many years am I going to have to wait for that decision? So it definitely put a real chilling effect on industry activity in those states. And again, New York consumers have been particularly big losers on this front. So.
Yeah, and Jeremy and I know we're fascinated by these sort of the interaction between state and federal law in these cases, and so from sort of the legal nerd standpoint, it was interesting. But man, it was a tough nut to crack. But then, the worm starts to turn. The good news starts coming in 2020 with the OCC and FDIC regs. And Jeremy, maybe you can explain sort of what happened there, and how those came to be, and a little bit of background on them.
Yeah, sure. I mean, so federal regulators were watching a lot of the things that Frank was talking about and that you were talking about, Steve, with the Madden decision. And of course, they're concerned about it because, they care about protecting U.S. markets and making sure there's an efficient credit market. And so about 5 years ago and about 5 years after Madden, both of the agencies you mentioned, the FDIC and the Office of the Comptroller, issued regulations that reaffirm the valid when made rule. And sometimes people would call these the Madden fix rule, but it was really about going back to valid when made. And of course, federal agencies have a role to play in interpreting the federal statutes that they administer, that they're responsible for. And here, the comptroller is responsible for the National Bank Act, and the FDIC for the Federal Deposit Insurance Act. And so both agencies went back, took a careful look at the statutory text, the structure, the history of the statutes, the reasons that Congress enacted them, and then issued interpretations of those statutes explaining how and why each of the statutes incorporates the valid when made rule. And it's important that what the agencies were doing was interpreting the statutes. In other words, sometimes we think of agencies as making freestanding policy decisions. That's not what they were doing here. They were going and taking a look at the arguments that you mentioned, Steve. The Madden court did not have an opportunity to consider, and explaining how the statutes incorporate the common law valid when made rule.
Yeah, and Jeremy, I mean, I think the agencies deserve credit for doing a really good job in how they reasoned and put these rules together, which obviously we'll talk about in a few minutes here, but that has a profound effect down the road. I don't know if you have anything else to say on that.
Well, no, I mean, I agree with that. In addition to the statutes, the agencies, they cited sort of their own supervisory experience in terms of looking at how the record they'd assembled on how this had played out in practice and comparing that to Congress's purposes and enacting the statute. And one thing that was, really particularly significant about the regulations is that although they were adopted by the first Trump administration, they cited a legal analysis that was developed by the Solicitor General under the Obama administration. And then, of course, after the rules come out, rules are always challenged in federal court. You have the Biden administration defending the rules because by that time, that administration had taken over. And then, of course, here we are now in the second Trump administration, and the rules have been retained. And so at this point, you have 4 presidential administrations in a row agreeing with these rules, which has really increased their persuasiveness in the courts and elsewhere.
Yeah, I think that's a really important point, and I don't think I think I neglected to mention, that first Solicitor General opinion came from the Obama administration, and it's here we are all these years later, still the administrations are still supporting them. Frank, I guess back to you. After the rules came out, how did industry react then? How did they help, and sort of how did things develop after the rules?
Sure. I think it's been interesting, again, maybe because of the overhang, of the rules. I think the market has responded cautiously. There were a number of market participants, folks at some of the ratings agencies and others who, agreed, okay, it looks like Madden is effectively limited to its to the holding and to the circumstances in that case. But but again, investors don't like to take any risk, and so the immediate uptake was a little slow, and folks have found some workarounds, including in some securitization transactions, you'll see opinions being delivered, but maybe it was slower than I would have liked, or that many others would have liked. But it has been steady and consistent. So I think we'll get later to kind of where we stand today. But I feel like market participants increasingly have recognized the power and the force of these regulations, and that they apply broadly. So.
Yeah, and I like you said, we'll get to sort of where we are today, but I think sort of it's a segue to kind of how courts reacted since the rules, and I think the way that they've been reacting should be giving the market a lot more comfort. I mean, first of all, Jeremy mentioned the Biden administration defending the rules. They were challenged under the APA. This is pre-Chevron, and were upheld. So that was a good start. They were, they were legitimate rules. And then you have outside the Second Circuit, really a rejection of Madden, I think is fair to say. Ninth Circuit, the Third Circuit, you had a concurrence where one of the judges, basically found the preemptive effect of the regs, which was a really important aspect of the regs that I'm not sure we even really got into a lot, but that they would preempt these state laws. So you have a couple other circuits that are really supporting the regulations. A couple other district courts, and then interestingly, you even start to see some courts within the Second Circuit, basically ruling against, not ruling against, sort of not giving Madden as much credence, trying to work around it, seemingly in recognition that it was just decided wrong. And I think what you've seen sort of judicially, which hopefully is going to be giving industry even more comfort about this, and the ratings agencies even more comfort, is that while Madden may be alive, technically the everyone else seems to have moved on and try to keep it to limit it to its facts. And I'll also point out, to the extent it ever ends up being litigated in the Second Circuit, we're in a very different Second Circuit. I mean, the two of the judges on the Madden panel are no longer there. 11 of the 13 judges are new since the decision. So, I mean, it's a very different world there, and a world much more favorable, I think, to the result that industry wants.
I mean, and to be fair, even to the Madden court itself, the issue wasn't briefed. So, like, if it had been presented by the parties, it may have come out very differently. And our system depends on adversarial presentation, and when that doesn't happen, you get decisions that are mistaken. So,
yeah, it's so true. I mentioned that earlier, but it's amazing how sort of bad briefing, or the old adage, bad facts make bad law, but so is bad briefing sometimes. And if you didn't, with this argument not being there, I mean, it just affected so much. And then, of course, everyone's been talking about the Loper-Bright decision, and rightfully so, since it came out last summer. And I guess, Jeremy, to what extent does Loper-Bright change any of this positive momentum on the regulations?
yeah, I mean, so Loper-Bright, overturned Chevron deference, which is the idea that as long as what the agency does is reasonable, courts will defer. And so sometimes people think, well, now that courts are interpreting laws without deferring to agencies, that means the agencies are always going to lose. That's not really true. What Loper-Bright means is that agencies lose when they do a bad job, but agencies win when they do a good job, is really the upshot of the decision. And of course, the court in that decision talked about how it's important to listen to the expert opinions of those that administer the statutes and all of that. And here, because the valid when made regulations are, different than some regulations in the sense that it wasn't the agency saying, hey, we think this is a great policy idea, and so we're going to enact this rule, but instead taking a thorough look at the statute, its history, its purpose, just the text of the statute, what Congress was trying to accomplish in terms of preemption when they enacted it, and adopting a legal rationale that was developed by the Solicitor General, which, of course, one of the most respected legal advocates in the United States, and adopting that into the regs, explaining why the statute, explaining what the statute means. Then, the change from the Chevron regime to the Loper-Bright regime probably is not going to have much effect here. They're good rules. They are the best interpretation of the statute. And so when a court looks and tries to determine the best interpretation of the statute, they're more than likely going to agree with the agency, which is what has been happening, unsurprisingly.
And that
Yeah,
sort of,
I would say,
oh yeah, I was going to ask Frank if you
I'm
wanted
sorry,
to.
Steve. I was just going to say, I mean, I do think that the consistency of viewpoint across, for better or for worse, administrations, Republicans, Democrats, et cetera, is giving market participants increasing comfort that these rules, are effective, and that investors, most importantly, investors, are not taking any risk in this area, that loans that they're purchasing will be somehow found invalid. And that, that remains the outstanding concern. And while in some structures people are still asking for what they've been asking for, opinions or other mechanisms, I think increasingly we're seeing that as time passes, and some investors are coming back in and purchasing loans with the view that they're valid and not seeking a premium even for that. And I think that that's really where this gets to, is that investors can, really should be monitoring this closely and seeking to get back into the market, because I think relatively soon those premiums that are being asked for additional risk will go away. And so there remains an open window, but I think it's closing.
Well, that's terrific. And I was going to ask you both sort of where we stand, but I think you both, Jeremy legally and Frank in the industry, I think you both addressed that. So I guess I'll just ask if you either one of you have any final thoughts on where we go or where this is headed next.
I mean, in law, like older is often better. I mean, here we've got a 100-year-old rule that's now been, because it was called into question, reaffirmed by the last 4 presidential administrations, and now the lower courts as they look at the rules and enforce them. And so, as a result, you've got lower courts enforcing the Supreme Court's rule, that rules that are valid when they're originated are valid when they're transferred. And the Madden decision's really fallen by the wayside.
And I was going to say, from an industry perspective, and given the importance of private equity and hedge funds and those pools of capital to our commerce and industry and to the capital markets, I think these rules are necessary and important, and that has just grown. So I would think maybe even by 2030, there'll be very few people who look back and say, "Remember that Madden thing?" And we'll be sort of back to business status quo ante. So this will have been a moment in time.
Well, it's hard to end on a better note than that. So thank you, Jeremy. Thank you, Frank. This has been fun. Maybe we'll do it again sometime. And thanks to AFSA for hosting this. And thanks everyone for listening. Have a good day.
Thanks for listening to the AFSA Extra Credit Podcast. To learn more about our guests today, check out the show notes wherever you get podcasts or at afsaonline.org/podcast. While you're there, be sure to browse our other great resources, including the blog, which is an excellent source for the latest from AFSA. Be sure to follow AFSA on X at AFSA_DC and AFSA State Government Affairs Team at AFSA_SGA. You can also follow us on LinkedIn. Just search for the name. Tune in next time for more Extra Credit. Thanks for listening.